Garland. I represent Chauncey Hopkins, who's the plaintiff appellant. The facts that give rise to this case are fairly straightforward.
Would you like to reserve any rebuttal time?
Oh, I'm sorry, Your Honor. Yes. I'd like to reserve 3 minutes' time.
3 minutes. All right, sir. You may proceed.
Thank you, Your Honor. The facts that give rise to this claim are fairly straightforward. My client was driving behind the defendant's vehicle. The defendant was essentially a semi-truck. As they were driving, the defendant's vehicle moved to the left lane, out of the lane where my client was driving, and then turned sharply over to go into an entrance to a UPS facility. It's my client's contention that he did so unexpectedly, causing my client to attempt to stop but fail, and as a result struck the defendant's vehicle, and my client was injured as a result. This case followed a fairly quick posture. The scheduling order was put down on June 21st. My client amended his complaint on July 1st of 2022, just less than a month later, a few weeks later. This was granted by the court on August 25, 2022. The court had put a scheduling order down that required fairly rapid disclosures. The plaintiff then attempted to make all of the disclosures.
Did you agree to the scheduling order?
The court ordered it, so I believe it was an agreed order, but
okay.
I think the court ordered it, so agreed or not, it is the operative law of the case, and I don't dispute that.
I understand, but I'm just trying to make sure that this wasn't something arbitrary, that normally the court takes into consideration the parties' thoughts about entering a scheduling order.
Your Honor, and I don't know if it was agreed or if it was ordered by the court after discussion or just ordered, and I can't say one way or the other. It's located at volume 4, page 482 of the record. If the court has an interest, then that would be where you would find it.
Okay.
The primary issue the appellant has is the motion for summary judgment filed by the defendant and granted by the trial court. In that the the defendant filed the motion for summary judgment, and in his statement of undisputed facts cited a number of facts from the plaintiff's complaint as undisputed. Obviously, we do agree that they're undisputed. He cited his first section, the date and time of the accident was cited to the plaintiff's complaint, which was he cited as docket 57, which was the court's internal docketing number. He cited to the facts of the accident, and I'm reading from the plaintiff's or the defendant's statement of undisputed facts. It says, on July 1st, 2020, Bernard Moore was the authorized driver of the 2018 Kenworth TR as an agent, employee, or servant of UPS, which was involved in an accident with the plaintiff on July 1st, 2020. See generally docket 57, plaintiff's first amended complaint, section 9. And this is the undisputed fact that the defendant put before the court in his statement of undisputed facts to support his motion for summary judgment. He then goes on to cite, I believe I put in my brief, but 3 or 4 more facts that cite to the plaintiff's complaint for the instances of the accident. Facts including that the day was clear and my client did see the vehicle, which we have obviously put in our complaint and we admit are true. And based on those facts, my client, the trial counsel responded with what must be considered a statement of undisputed facts, although they created essentially a portmanteau of statement of undisputed facts plus additional facts and kind of stuck it together inartfully. I will concede the point. But it is a functional statement of undisputed facts where he went in and admitted, obviously, the facts that were in our complaint, we admit, and then supplemented with additional facts, which was the fact that the Kenworth moved to the left and then suddenly turned to the right, and that was the essential fact that caused the accident. The trial court, at this case, essentially rejected the statement of undisputed facts of the plaintiff, saying that we had not cited to an affidavit. I believe that is where the error in this case comes. While that is true, we did not cite to an affidavit. The rule, in fact, does not require citation to an affidavit. It says, upon summary judgment, the court shall consider all pleadings, motions, affidavits, depositions, request to admit, discovery, or any other facts submitted in the record. It is undisputed that our undisputed facts were in the record, since they largely consist of the plaintiff's complaint, which the defendant cited to in their statement of undisputed facts. And in fact, you're not required to submit an affidavit in response to summary judgment. There's a case directly on point, which I was unfortunately didn't find until I was doing research and other issues, but it's Carrick versus City of Shelbyville. 2021 10 app, and it's Alexis 309. It is an unreported case out of the Eastern Section. And in that case, the court had in fact ruled, there was a summary judgment case exactly like on our facts. The defendant's motion for summary judgment was supported by affidavit. The defendant, plaintiff in that case, cited to additional items in the record rather than an affidavit. And the court was very clear in its analysis that the trial court is to look at the record as a whole in a summary judgment and not simply only at affidavits. Affidavits are not the only mechanism by which an undisputed fact may be established. It may be established by, as in the prior case the courts have just heard, it may be established by a handwritten codicil. It may be established by a deed. There are other items besides an affidavit which would support a statement of fact.
And what was the evidence that supported these facts?
It was the statements of the plaintiff in the complaint, Your Honor.
Are those evidence?
It is it is evidence, Your Honor, and we know it's evidence because the defendant said those were the facts and cited to the plaintiff's complaint as a fact.
Aren't they just mere allegations?
No, Your Honor.
Was the complaint sworn to?
No, Your Honor, but it doesn't need to be.
Were there any affidavits in support of the motion for summary judgment?
I don't believe so. But I don't know. I do know that they cited to the plaintiff's complaint for what are the factual allegations in the complaint. Their summary judgment was...
Can't they agree to facts? If you say it was raining.
Yes.
Can't they agree that it was raining and that becomes an undisputed fact?
That's correct, Your Honor. And we don't dispute the facts they cite from our complaint.
But in order for it to become an undisputed fact, they have to agree to it, correct? Or you have to prove it by evidence.
Well, that's correct, Your Honor. And I would just point to the court, the Rule 5603 that says that the court in a summary judgment is to look at the pleadings, motions, and other evidence before the court. That it is not only by affidavits, you may use pleadings. It does not say to address Judge Golden's position. It does not say verified complaint. It could have said verified pleadings in the rule and did not.
Doesn't that actually mean just responses to discovery, requests to admit, those type things?
No, sir, because it says in the rule, it says pleadings, motions, it says pleadings, motions, and other issues in the record, Your Honor. And so...
Where are you reading from?
I'm sorry, I'm trying to, 5604, the non-moving party shall prevail if pleadings, depositions, answers to interrogatory, and admissions on file, together with affidavits, if any, show that there is no genuine issue as to any material fact that the moving party is entitled to judgment as a matter of law. And that's 5604. And it even says affidavits, if any. And so I think the plaintiff position would be is that pleadings mean pleadings. And that the court did not narrow, the legislature did not, and the court effectively, did not narrow it by the drafting of this rule, but rather said pleadings and means pleadings.
So if, I want to make sure I'm logically following what you're saying.
Yes, Your Honor.
As long as a plaintiff has filed a complaint, summary judgment can never be granted.
No, Your Honor, absolutely not. There are certainly plenty of complaints, hopefully not a lot, but there are plenty that you do.
A complaint is asserting one set of facts.
It is asserting a set of facts, Your Honor, but of course, a lot of times when you file a complaint, even if a person is correct on every fact, they may not, in fact, be able to prevail as a matter of law.
Well, as a matter of law, summary judgment can't be granted because it would be theoretically disputed material facts.
No, Your Honor, because the facts may be disputed or undisputed. If the facts are undisputed, then as a matter of law, there must be one result. And that's where summary judgment comes in. It's not designed to pretermit the determination of facts. There are plenty of occasions, and the point of a summary judgment is if everything that the plaintiff or the non-moving party alleges is true, they still may not, as a matter of law, prevail. And it's,
Well, let me try it a different way.
okay, Your Honor, I'm sorry.
In this instance, the only thing that you're actually relying upon is the complaint, what you've asserted in the complaint, to respond to the defendant's summary judgment motion. Would that be accurate?
I'm not sure that's accurate. I believe that there are other facts that were cited, but as far as causation, which is essentially our case, why did the accident occur is where the summary judgment was granted. Granted essentially, and
did you respond by way of affidavit or discovery responses or depositions or any of those things?
I believe there were responses that were addressed to discovery responses, but the issue of causation, which is what the summary judgment was granted upon, turned on the facts in the complaint. And the facts that the defendant cited from our complaint, and it seems peculiar in reading the record that the defendant cited to our complaint, but we cannot then cite to our complaint in response, or to add additional facts from our complaint they did not include in their statement of undisputed facts. And I don't think there was a dispute as to the facts that we submitted in our statement of undisputed facts. That he did move over in the other lane and he did attempt to turn into that. And the only issue is an issue for the jury. Did that over to the other lane and turn into the facility cause the accident, or was our client responsible for failing to stop because the vehicle in front of him then made this turn?
Thank you.
Thank you.
Time.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court, my name is Ronna Kinsella. I'm with the law firm of Glassman, Wyatt, Tuttle & Cox in Memphis, Tennessee, and I'm here today on behalf of the defendant Appellee, United Parcel Service, Inc. I will be frank with Your Honors that I have struggled with today's oral argument. I am in the unenviable position that despite my experience in handling dispositive motions and even appellate arguments before this and other courts, I've never been part before today to a case quite as extraordinary as this one. And in all honesty, as I told Judge Wagner when she ruled upon my motion for summary judgment in this case, I'm not entirely sure why we're here. My esteemed colleague, Mr. Garland, is at a bit of a disadvantage because he was not trial counsel in this underlying case and is appearing only for parts of the appeal. So there's some parts to the record today that he just simply may not be aware of, and I think it's only pertinent to draw Your Honor's attention to that. The motions at issue, specifically the exclusion of the plaintiff's experts in this case, and the subsequent grant of motion for summary judgment filed by my clients, was the result of a very lengthy and somewhat acrimonious discovery process in this case. As Mr. Garland denoted, this accident happened back on July 1st of 2020. Plaintiff filed suit on July 1, 2021. My client subsequently answers, appears, and propounds a set of discovery to the plaintiffs to answer a host of really unsupported claims that we held at the time were frankly sanctionable under Rule 11 because there was no basis for it. The facts of the accident have always been in dispute. My client's position has always been in this case that Mr. Hopkins rear-ended the UPS driver who was driving lawfully and making a left-hand turn. Mr. Garland may not have been aware of that, but that has been...
You said a left turn, you meant a right turn?
I'm sorry, a right turn, yes.
Okay.
But that has always been at issue in this case. On April 18th of 2022, there was a first round of discovery motions filed by my client related to several of these ongoing issues. Subsequent hearings were held on June 7th and June 13th. Judge Wagner had to split it into 2 hearings because it took so long, and there were so many issues in dispute. As a result of those hearings, the court did instruct the parties to work together to craft a scheduling order, which Your Honors mentioned earlier, that was the product of agreements between counsel. One of those agreements required that plaintiffs' counsel provide their expert disclosures by no later than August 7th of 2022. Shortly before that deadline occurred, plaintiffs' counsel filed a motion to extend time. Over mine and my client's very strenuous objections because nothing had been done in the case up to that point by the plaintiff. The trial court nevertheless granted the plaintiffs an additional extension of time in which to disclose their experts. She warned them at the time of the hearing, and we've included the transcripts of those hearings in our appendix that was not included in part of the record. She warned them at the time that, guys, look, this is the deadline. We have no more time to extend these deadlines. Those deadlines came and went. On October 13th, 2022, shortly before the plaintiff's October 24th deadline to disclose expert disclosures, plaintiff filed supplemental responses to our discovery request purporting to disclose 4 experts. Those disclosures were in no way, even by plaintiff's counsel's own admissions at trial and at subsequent hearings and in subsequent pleadings in their response to our motion to strike, they were never once compliant with the requirements of Rule 26.04 in terms of expert disclosure. They did not disclose the expert's opinions, the basis for those opinions. They didn't provide us the CV. They didn't provide us the testimony list. They didn't provide us with the amount of compensation paid. None of that was provided by the October 24th extended deadline that the plaintiff themselves asked the trial court for. None of that happened. We went back and forth. Again, this is in the record, with multiple good faith consultations with plaintiff's counsel requesting supplementation to those disclosures, and never received the actual reports. Come to find out, the only report that was subsequently produced to us was produced long after the deadline, was still not in compliance with the rules, and subsequently the plaintiff didn't even attempt to obtain that expert disclosure until 2 weeks after the deadline had passed. At no point in time did they come to the trial court or to us and ask for additional time or further extensions. They made no good faith argument or presentation to the trial court for the further extension of those deadlines. And as a result, when the court held its hearing on that matter back on November 14th of 2022, November 29th, 2022 is when the court held the hearing. The trial court specifically found and put in its order, you did not comply with the rules. I gave you the extension deadline, repeatedly told you through discovery responses that you had to provide this information to my client, UPS, and the trial court found that they did not do so and struck their experts. I will submit to Your Honors, frankly, that the issue of the trial court striking the experts, which is, as you know, governed under our abuse of discretion standard, is frankly a red herring. It makes no difference for the purposes of the dispositive outcome of this case because plaintiff never tried to present any additional evidence related to those experts at any point in time. With regard to the motion for summary judgment, the reason that we are here today, I think the best way to approach it, quite frankly, is actually with Tennessee Code annotated 27-1-122. And that, frankly, is my client's request for sanctions for what is basically a frivolous appeal. Your honors have been present, obviously, this morning and heard two previous arguments on two different cases, arguing back and forth about what evidence showed, what it didn't show in response to a motion for summary judgment. In this case, there is no evidence, none. There's no deposition. There's no affidavit. There's no discovery responses. There's no request for admissions. There's no witness statements. There's no expert reports. There is no evidence as that term has ever been used within the law and the jurisprudence of this state. All the plaintiff has done is ask this court to overturn not only Rye and the standard of review for purposes of a motion for summary judgment by citing to what they should know by all accounts is an incorrect standard of law and an unpublished case decided under a previous governing rule for deciding motions for summary judgment under the Hannon case that was overruled by Rye in 2015. But they also asked this court to throw out Rule 56, the provisions regarding motions for summary judgment and how they're to be handled. They asked the court to throw out the rules of evidence, particularly those related to inadmissible hearsay and expert proof and opinion testimony. They asked the court to throw out provisions related to Rule 37, Rule 26, and Rule 16 with regard to a trial court's inherent right to govern its own schedule. In this case, Mr. Garland stood up and told this court that the trial court erred because it decided in the motion for summary judgment that the plaintiff did not cite to an affidavit and that that's where the error is, and that's what he argued to you guys here. Unfortunately, that's not true, and that's borne out not only in the trial court's order, which is part of the record, that states specifically that the plaintiff pointed to no evidence at all. Nothing in the record beyond his own amended complaint, which by the terms of the rules, 56.06, which Mr. Garland did not cite to this court today, says very clearly that the non-movement cannot rely on their pleadings alone. They have to rely on admissible evidence in response to a properly supported motion for summary judgment. We're allowed to use statements that the plaintiff makes in his amended complaint because the plaintiff has made those statements. They're admissions by a party opponent. But that does not mean that by simply stating as a plaintiff, I have other facts that I allege, and I'm using the terms facts loosely, that I then get to use my own inadmissible hearsay and my own inadmissible opinion to do, as Judge Stafford suggested earlier, and say basically anytime a plaintiff has a complaint, we no longer get to have a motion for summary judgment. That's simply not the case. Tennessee Code Annotated 27-1-122 says that when it appears to any reviewing court that the appeal from any court of record was frivolous or taken solely for delay, the court may, either upon motion of a party or its own motion, award just damages against the appellant, which may include, but need not be limited to, costs, interest on the judgment, and expenses incurred by the appellee as a result of that appeal. This court has previously held that an appeal is frivolous when it has no reasonable chance of success or is so utterly devoid of merit as to justify the imposition of a penalty, and failure to cite any evidence or rule of law entitling the appealing party to relief is an indicator that the appeal may be frivolous. I would submit to your honors in this case, if there ever was a case for the award of damages as a result of a frivolous appeal, this is one. This case never should have had to go to a motion for summary judgment. The trial court specifically did not rule merely on breach of duty or causation, didn't rule specifically on the issue of whether or not the plaintiff had an affidavit. In fact, I'm going to quote from the order that was entered by the trial court. She states in part that Rule 56 is very clear. It contains a very specific procedure for the parties to follow. Tennessee Rules of Civil Procedure 56.03 requires that in order to assist the court in ascertaining whether there are any material facts in dispute, any motion for summary judgment shall be accompanied by a separate and concise statement of material facts as to which the moving party contends there is not a genuine issue for trial. She then goes on to state that any party opposing a motion for summary judgment must, not later than 5 days before the hearing, file and serve a response to each fact set forth by the movement, either 1, agreeing that the fact at issue is undisputed, 2, agreeing that the fact is undisputed for purposes of ruling on the motion for summary judgment, or 3, demonstrating that the fact is disputed. Each disputed fact must be supported by a specific citation to the record. The court goes on to cite Rule 56.06 and says, when the motion for summary judgment is made and supported as provided in the rules, the adverse party may not rest upon the mere allegations or denials of the adverse party's pleading, but his response by affidavits or otherwise, as provided in this rule, must set forth specific facts showing that there's a genuine issue for trial. Judge Wagner writes, that is the crux of the issue in this case. The plaintiff may not rest on his mere allegations as contained within his complaint. Plaintiff has again failed to comply with the rules in this case, and in their response to the defendant's motion for summary judgment, the defendant, and I'm skipping ahead, filed a statement of undisputed facts supported by citations to applicable portions of the record. My client did what they were supposed to do. The court notes these undisputed facts have not been responded to by the plaintiff at all. There was no response to our statement for undisputed facts. Instead, what the plaintiff did was file a statement of alternate facts, where he cites only to his own unsworn amended complaint and to the allegations made within that unsworn complaint, which, again, have always been in dispute. No citations to the record have been provided, nor has the plaintiff directed this court to any evidence whatsoever as would be admissible at trial to support any of the essential elements of his claim, namely any issue of duty, breach of duty, causation, or damages. Today, the plaintiff has not pointed you to a single fact or a single operation in the record. He asks you to overwrite not only more than a decade of this court's own jurisprudence, but the Tennessee Rules of Civil Procedure and the Tennessee Rules of Evidence to hold, as you would be required to do should you overturn this decision, that the plaintiff, anytime is faced with a motion for summary judgment, is entitled to ignore the rules, cite only to his own unsupported, unsworn, and inadmissible self-serving statements, and thereby defeat a properly supported motion for summary judgment. There is no possibility that there is any merit to this opinion at all. And I would submit to you that when a plaintiff has to misrepresent the record, has to leave out portions of available trial transcripts, available portions of the court's own signed orders that are part of this court's record, and misrepresent the actual standard by which summary judgment motions are applied, misrepresent the facts of his own experts' disclosures in order to try to get around the fact that he did not meet his own agreed to and extended twice deadline, this is grounds for a frivolous appeal, and the court should take it as such. We ask that you uphold the trial court's rulings, and we ask that you award us our expenses for this frivolous appeal. Thank you, Your Honors.
Thank you. I believe you have 3 minutes.
Thank you, Your Honor. I honestly don't know how to respond to the argument for sanctions. I noticed when I read the record, it seemed, I don't know the history between these two firms. I would seem to stipulate it as acrimonious. Seems like every 45 days or so, the defendant's filing some motion which includes a sanction provision. I don't know what has gone below. I'm just going to address it for my merits of my pleadings. And I cite 5604. I'm not asking the court to overturn 56. I don't want to do anything like that. 56.04 says, summary judgment shall be rendered if the pleadings, depositions, answers to interrogatories, and admissions on file, together with affidavits, if any, show that there is no material issue. And that's what I'm relying on, Your Honor. I would also point out, again, the unfairness of the defendant saying that, well, I can cite to the plaintiff's complaint as a citation to the record, and making a citation to the record, docket 57, section 9 of my plaintiff's complaint, to support our factual averments. And then when we use our plaintiff's complaint to add additional averments, then that is somehow inappropriate. I don't see how we can square that particular circle on an equity basis. The second thing I would say, Your Honor, is the general rule that that summary judgment for liability prong, which is essentially where we're at, on personal injury cases is generally disfavored, is generally not appropriate. In our case, even the facts that they cited, I think may get us to a jury. The fact that my client was driving behind the person was driving in front of us. There was a collision which, was caused. The facts we added that came from our complaint was simply that he moved into the left-hand lane and then turned right in the facility. That is the sum total of additional facts that give rise to liability. And as she said when she first started her argument, the facts are hotly in dispute. Well, if the facts are hotly in dispute, Your Honor, that's an issue for the jury. And I think that's where this case on liability needs to go. As far as touching upon the experts' disclosures, which obviously if we don't prevail on the liability issue are not of moment, I would stipulate, and I did in my brief outline, that 24th was the date that my client, the counsel received the expert report on November 2nd. He forwarded it on November 9th. The hearing was subsequently held. We concede in our brief that they did not meet the deadline for the expert disclosures. I put the facts in my brief to show that it was not due to negligence on the part of the plaintiff, who ultimately suffers the burden of not having the experts, or the counsel who did not receive it for the report from the experts and the information from the experts, which he supplemented till the 2nd of November, which was after the deadline. This is a situation, I'm sorry, I've run over. My apologies, Your Honor.
No problem. Thank you.
Thank you, Your Honor.
Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. We will be in recess till the call of the docket this afternoon.
All right.
Thank you.
This honorable court is now in recess.